Good afternoon. My name is Brendan Manning. I'm the Vice President of Education and Environment with the AGC of New York. I want to welcome everybody to our Series 2, Prompt Payment and Retainage on Private Work. Again, we're going to, as we did the first week, everyone should have a Q&A box if you have any questions for our panelists. At this point, I think I'll turn it over to Josh Bell or Joe Hogan to do a quick introduction.
Turn it over to me, Brendan. Okay. For those who don't know me, which would be shocking, I'm Joe Hogan, Vice President of Building for AGC, and I want to welcome you to episode 2 of the Lunch and Crunch series, which is held the third Wednesday of every month. This month's session is on prompt payment retainage relative to private work. Next month will be relative to public work, and interestingly enough, besides a lot of the usual issues on payment that as we get into this, the panel will talk about. In New York, we have sort of special laws governing private work, prompt payment, and retainage. And perhaps more importantly, you have a relatively new and significant risk relative to wage theft that we'll talk about toward the end of this session. I want to introduce the panel. Moderating with Josh Levy, CEO and co-founder of Document Crunch, which is an organization that we're very, very happy to partner with to provide our members, as is our mantra, tools to help you better manage your business. And then with Josh Levy is Josh Bell, who's the Director of Industry Solutions for Document Crunch, and certainly between the two of them with their background, you've got a tremendous panel here. So with that, Josh Levy, why don't I turn it over to you to talk about a little bit about Document Crunch and the relationship with AGC.
Yeah, thanks so much, Joe, and thank you to the attendees here today. Look, I want to applaud the AGC New York for being super innovative and partnering with Document Crunch. We're a software company, really with the purpose of hopefully providing value to your members for you all so that you can get educated around issues in construction contracts, which hopefully reduces risks at the project level. So that's really what our mission is and what we're here for. And the AGC New York has done a tremendous job embracing technology and making it available for you folks out there that are AGC New York members. So our company, just real quickly, we rapidly find issues in construction contracts that are important, and we provide guidance around those issues. Again, to achieve that objective is helping make contracts less painful and easier to understand for everyone in the industry. And in the case of the AGC New York, the AGC New York has a specialized, piece of our platform where AGC of New York members can upload their contracts, understand where those issues are, which is kind of our core product function, but then have the AGC New York's guidance around those particular issues. So a real New York flavor, and frankly, the AGC's kind of views, rationale around those issues. We'll show you some of that in the presentation today. But that's really what this partnership is about. I will say that you all are a real leader. This chapter is a real leader nationally. We've received a lot of attention from other AGC chapters, but also other trade organizations. In fact, the National Electrical Contractors Organization, their think tank, just announced a partnership with us last week. Frankly, it was announced, and I think a lot of that's on the back of how Joe and the AGC New York is thinking about using the platform that these organizations have, and then kind of leveraging technology to make our industry better. And so again, I applaud the AGC New York, and otherwise we can turn it over to the regularly scheduled programming all around payment and some of the New York considerations associated with payment. And again, you'll get a good kind of taste for the product and how we can help make this easier as we go through this today. Joe, I think you may be muted.
Yeah, I am. Josh Bell, I'll let you kind of start us off on this.
Thanks, Joe. Yeah, so this is our project manager cheat sheet that just is a cliff notes of the things in the contract. So we wanted to highlight, like, first of all, the prompt payment is going to take you to where it is in the contract. I think the important thing here is that for those that do work in other states, this is they may have different requirements around prompt pay and retainage and things like that. So it's good to know what those things are and and we can help you quickly identify the provisions in the contract. So if you need to raise that with your owner or your upstream party, that you can do that.
Hey, and Josh, maybe I can just steal a little of your thunder here and what, Josh Bell is a longtime construction attorney. He's had several in-house positions, most recently for a couple of really large contractors. I have the exact same background. And so I ran a couple of legal departments in my time before founding Document Crunch as well for large contractors. And the reason why I'm saying this is a lot of times folks in our industry think about contracts and they say, oh, well, the Joshes of the world or the lawyers of the world or the executives of the world, they deal with all this stuff, right? The negotiation, the signing, whatever it is. The reality is, and why we're showing you a project management cheat sheet, is that you at the project level, or you folks that have operations at the project level, folks need to understand a lot of this stuff to run successful projects. And so this cheat sheet is not so much about negotiation or, like signing a contract. This cheat sheet is saying, hey, you're at the project level and here's a playbook for the types of things that you better know about if you're going to make good decisions day to day. And again, this goes to like the direct mission of, I think, what the AGC New York and Document Crunch is trying to do. If we can provide a little bit more comfort to those people wearing hard hats every day, if we can get them a little bit more educated, if we can give them a little bit more wherewithal around these issues, our industry will perform better on its projects, which means that we will be more profitable. We will have less claims. We'll have smoother projects. And so when we show you a project management cheat sheet, I think it's just really important to understand this is geared for project managers, project executives, or even VPs or other execs that just want a bird's eye view as to what's going on in their day-to-day contracts.
Yeah, thanks, Josh. I will say too that practical implications of this, just a real world example is like in the project in the South, that where in a state where they have, in the state of Texas, where they had prompt pay and the owners was like, their contract didn't comply with that. And they went ahead and said, we're going to proceed with something that doesn't comply with that. The downstream parties will definitely know this. So what it did was it created a cash flow nightmare, honestly, because those parties knew that there was prompt pay. So if it ended up being a situation where we were having to bankroll or finance the project to keep it running smoothly. So just be aware of some of those practical implications. And the reason why this stuff matters is because the prompt pay and retainage, I think downstream parties are definitely going to know that.
Hit the next slide, Brendan.
Yeah, so this is just an example of what if you the hyperlinks in that cheat sheet will actually take you to right to where it says in the contract about what are your progress payment terms and that sort of thing. And like I mentioned earlier, so I worked with on the owner side up with a lot of projects in the Northeast. And so like Connecticut, for example, would have things around prompt pay and retainage and things like that. So if that were not your standard, I guess, that were something other than that. So I think that when I say standard, like your standard payment terms or your standard retainage amount of 10%, if it was less than that, excuse me, it's going to show you that. So just being aware of what that is and if it's properly reflected in the contract, because I mentioned earlier, the downstream trade contractors or whatnot are going to be aware of that for sure.
One of the things that's I think interesting and important as you look at the requirements here, the application for payment, and what is required to put that in, who it goes to is important. But one of the things that is something that I see is the issue of change orders, and at what point in time you include those in the payment requisition, particularly coming from subcontractors. As we talk in a little bit about the New York State prompt payment laws on private work, same will happen on public work. And if you end up with an unapproved change order that a subcontractor is included in their requisition, and you include it in this requisition, it could cause you major headaches, major problems downstream as you go through the process. And so, adhering to these things and really paying attention to what the subcontractors are putting in, what you're suggesting, and what you have included on that. Look at the language there: properly authorized change orders. So you almost have to go back then to the change order process and make sure you're there. In similar fashion, the interim directives and what are the payment pieces of that. As I said, if you go off of what the strict terms are in this regard, it may cause you real headaches relative to your downstream subcontractor payments. One other thing that I'll note here is the idea of stored material and equipment. This becomes extremely important, understanding those terms, because of supply chain issues. And one of the things that we've been stressing with owners and with designers is you need to be very, very liberal, if you will, with regard to payment for stored materials in order to minimize the impact. And so understanding this piece becomes important as well. Next slide, Brendan. So this is some of the pieces that we've added. We'll talk about public work next go round, but if you go down where it says private work, we have Article 35E of the New York State General Business Law, which governs. Now, when this law was passed, we had opposed the law, basically suggesting that the state should not get in between a private owner and a contractor. Of course, the legislature didn't listen in this regard. They were being pushed by subcontractors, and subsequently the subcontractors have pushed further. That's important insight as to where the rationale and the impetus for this law comes into play. So in New York State, no matter what the terms say, and no matter what becomes an interesting question, upon submission of an invoice to the owner, they have just 12 business days to approve or disapprove the invoice. Now, does that include the paper rec? Pencil rec? I would say no. That's where the process comes in. It also comes into play as to who that submission goes to. Have you submitted it to the right player? Start that clock ticking. If there is to be a disapproval of all or a portion of the invoice, the owner must provide a written statement laying out what has been disapproved and why, and the valid reasons for the disapproval are unsatisfactory or just disputed job progress, defective construction work, disputed work materials, failure to comply with other material provisions, failure to make timely payment for labor, damage to the owner, evidence contract can't be completed for outstanding contract sum. Those are valid reasons, but within 12 business days, the owner is supposed to give you that information. Now, it brings up a question. It was something that we had suggested, and it'll be important as we talk about the subcontractor piece as well. With a private owner that doesn't, and a client, a valued client, depending on the type of client. There's one particular very large owner in New York State that pretty much thumbs their nose at all of this stuff, and that Josh Bell, I think, knows well. The question is, are you going to balk? Are you going to say, hey, your contract is illegal. You're not following the law? And it's all right. Well, we'll follow the law. This will be the last contract you worked with us on. And that's always a difficult position to be in. Understand, though, as we talk about the subcontractor piece of it, by not pushing back, maybe gently, you may put yourself at risk. Now, the subcontractors face the same issue as you, however, from a client relation standpoint. And I remember being at a subcontractors trade association meeting in New York City several years ago, and lawyers standing up there basically begging the subcontractors to actually force contractors and owners to comply with the law so they could, frankly, in my money, no offense to the lawyers, make some money in representing the subcontractors in the push for that. To their credit, the subcontractors there were pretty much of the same mindset. Yeah, know your subcontractors. Do you have a subcontractor that maybe has been pushed too hard? Is there a subcontractor that may be in trouble? Is there a subcontractor that doesn't really care, about client relationships? Because there are those that you may be dealing with. Understand where the risk is as we go into the next piece. Brendan, go to the next slide.
Hey, Joe, if I could just a couple of things. So Joe is, and I know this now and getting to work with him for the better part of the last year, but Joe is such a resource to the AGC New York constituency. And I know a lot of folks call on Joe for help with some of these items. The ability for this now to have been baked into something that can be used as an education tool, which Joe is just showing you kind of like how that product would work. I think it's important, and it's important for more just the education. What Joe just hit on, you're not always going to be able to negotiate these things. You're not always going to be able to change these things, but awareness and knowing what's going on is everything, because it may change how you manage those things. Like in the case of having that tough clause, but knowing your subcontractors, just having awareness of these issues gives you at least a puncher's chance to maybe, make a good decision or handle something a little bit more tactfully or whatever. And so that's what we're really trying to do, is kind of give some of that wisdom to you folks so that you're running projects so that you can make better decisions around some of these issues, which you may be stuck with. By the time you get handed the contract, it may have that tough clause. And like to Joe's point, being aware of that clause and then knowing your subs is really important.
Next slide, Brendan. And again.
Yeah, I would just to kind of piggyback off what Joe had said is that some of these are compulsory, and in other words, you can contract around in some states, and some states you cannot. So if you have a provision that conflicts in those states, it's void, it's unenforceable. And I would say also to Joe's point about the tact that you take and as opposed with your owner, the most compelling thing on the owner side is saying, hey, look, this is going to create cash flow issues and delays if you do this, if you don't comply with the law. if your contract doesn't. And so that was the compelling thing on the owner side, is to say, hey, and frankly, on the general contractor side as well, is to say, hey, look, this is, if you do this, if you don't comply with the law, it's going to create potential delays and things like that. Because at the end of the day, I mean, the owner is wanting the most important thing on the owner side is just to have your project done on time. So I would say, that penny wise, pound foolish thing is saying, is it really worth it to, and you can sort of point out that, hey, if we don't have something that complies with the law, it's going to create issues. Because I mentioned earlier, your downstream subs are definitely going to know this. And then the other thing that the pay if, pay when thing about the conditional payment, just know that these conditional payments are not enforceable in a lot of jurisdictions. So like, if you have, just be aware of what is allowed in that jurisdiction, because if it says you don't get paid or pay your subs until you get paid by the owner, that is not enforceable in some jurisdictions. So in Joe, I can't remember offhand if it is in New York or not, but it's not. Okay.
It's not. So the next slide, Brendan. I think I've got this in the next slide. And again. So in the, there was a decision years ago, West Fair, is what we affectionately call it, contingent payment provisions, pay if paid in contracts and subcontracts, are void and unenforceable. So one of the questions I have, and every once in a while I'll see these contracts, particularly, for example, if you may be a national firm and you're using national documents and you haven't tailored those to New York State. One of the real worries I have is that if you leave a contingent payment clause in and that's void and unenforceable, does it make, for all intents and purposes, your entire subcontract payment provisions void and unenforceable? And have you lost a lot of the protections, a lot of the tools necessary because you haven't paid attention to New York State law and you put in a clause that's void and unenforceable?
Hey, Joe, I have a question. Is that pay if and pay when paid are unenforceable in New York?
So pay if is on void and enforceable, and effectively what it says is against Section 34 of the lien law, and therefore void. Pay when, however, is not unenforceable. That is an enforceable provision. So, Brendan, if you hit the next slide, I think it's the next slide, maybe two. Now, again. Okay, again. All right, somehow or other I lost the slide. Maybe it's later on. We have some language that I think will come up shortly, but we have some language that's recommended for that. Look at the key is to stretch it out as best you can, so you're not being a bank for an owner who is slow on payment, and make sure that you have all the tools necessary to stretch that out. But at some point in time, if the owner doesn't pay you, you're gonna at some point have to pay the subcontractor. And as I said, the key is to stretch that out as best as possible. And then it's a matter of also managing the subs from there. And this was one of the reasons also that the idea of knowing your subs and the change order piece are all very, very important. So let's talk, Josh Bell, about retainage here.
Yeah, and to your point, Joe, I mean, on the GC side of things, we found that a lot of like the national documents, the ones that the owners that did work all over the country, sometimes wouldn't consider, sometimes they did, but oftentimes they wouldn't consider like jurisdictional requirements. So I think 9 times out of 10, if you just, pointing that out to them, would be enough to want to, to change that contract. I know on the owner side, if that would be a compelling thing, because we didn't want to have an issue with completion and schedule and all of that. And also we wanted to comply with the law. So on the retainage part of it, the not only the percentage amount needs to comply with law, and like I mentioned Connecticut earlier, and I mean, testing my memory in my old age, but I think it was like 7.5%. So, but then also in the 924 about the release of retainage at 50%, that is also like, that's a compulsory state law where I am. So you need to know that as well. So let's just say, for example, that wasn't there, that wouldn't comply in this jurisdiction. And I think, Joe, you said also in New York, it's a similar thing. So, and that's pretty common in jurisdictions I found.
So this is one of the real tricky points with regard to subcontractor payment and the prompt payment law in New York, because the law in New York says that you can hold no more retainage from your subcontractor than the owner is holding on you. So it leads to a question. Let's say you've got a provision that you're going to hold 5% retainage on your subcontractor. And that's what the owner is effectively holding on you, or let's say they're holding 10%, so you're holding 10% on your sub. And at 50%, they reduce your retainage to 0 because everything is going fine. What do you do with your subcontractors? Can you, since you have not put retainage in relative to your requisition to an owner for any retainage at that point in time, can you still hold retainage on your subcontractor? I think that's a real open question, particularly on the late finishing subs. Now, if you've got a subcontractor that's going through the entire life of the project, then maybe that's one thing to manage. But let's say you've got your painter that isn't coming in until the latter portion. Does that mean you can hold no retainage on your painter? I think that's a potential real problem. So to be honest with you, to avoid that, I would almost rather just go to 5% all the way through.
Yeah.
And then you're clean on your subcontractors. Next slide, Brendan.
Joe, in your experience, do you think that project teams negotiate like retainage in subcontracts, or do you find that that's usually mandated by the corporate office?
Well, I think that's going to depend. I think that when the project manager is getting involved, and I think there are folks on this that are other than the PMs as well, but I think it's something to consider from a PM standpoint, where you have no ability to influence what the subcontract terms are going to be in this regard, or the owner terms, obviously. I think you just need to be aware of the risk here. That an educated subcontractor may become a real pain in the backside for you.
Yeah.
On this point, and you need to have a little bit of a strategy, and say that the effective, because of the way that the retainage is held, the effective retainage is 5%. Therefore, I'm holding 5% on you. But I think it's something you need to have in the back of your mind here. What's interesting here is we look at, again, down halfway on the private work piece, the law says on the owner to contractor that The retainage will be by mutual agreement. The owner will hold a reasonable amount of retainage, and reasonable amount is not defined, but it's clear to us that as a matter that should be covered in the agreement, it would seem 5 to 10% would be reasonable. How you push back on that, I don't know. But I think that, one of the questions is if you've got a contract where it's been silent on retainage, and pushing back and making sure, you understand what's going to be happening here. And maybe just by, by the progress of the job, I think they'll fall to industry practice. But retainage then is to be released no later than 30 days after final approval of the work, to less interest, and of 1% per month becoming due and owing the contractor subcontractor. So in other words, if they're holding retainage beyond that 30 days, you and your subcontractors are due 1% per month interest. Now, interestingly enough, there are certain remedies on late payments generally, this being one of them. And we'll talk more about this on the public works side because it's a little bit more acute there. One of the recommendations that I make is keep a running tally of the interest that the owner is going to owe you. Not that you will necessarily collect that interest. Although here on the private work, the subcontractors may be more interested in getting that interest. I found it or seen it to be used as a bargaining chip on change orders, late change orders, and working through that. But if you haven't got that calculated and keep a running tally on it, then it's a little bit more difficult to do that. Also on the retainage, a contractor may hold a reasonable amount of retainage on the progress payments of the subcontractors. But as I said, no greater than the amount the owner holds. And there's no distinction here in this law on that point of whether the sub is bonded or unbonded. And so, as I said before, this can create some difficulty. Let's say you've got an unbonded sub and your practice is to hold 10% on unbonded, 5% on bonded, but the owner's only holding 5% on you. Can you hold the 10% on the subcontractor? I don't know. That's a strategy to think about, and some other way to maybe call it something other than retainage. And I don't know, Josh, if you've got some thoughts on that. But that's always an issue, is the bonded versus unbonded, and it's more of a problem on private work because of the prompt payment law.
Yeah, I would agree. And I think at least the reality for me at a larger general contractor, and I don't know if Josh had the same experience, is that I didn't see the subcontracts. I mean, that was really for the operations team to deal with. So, and if you don't consider this stuff up front, that can be a real headache to deal with. So.
Yeah, I would say I have a pretty similar experience. I would only see the subcontracts once there was a problem.
Yeah, I mean,
go ahead.
Sorry, Joe, this is a war story that I can't help but share, but like the state of New Mexico doesn't allow retainage at all. Who knew? Right. So found out the hard way on that and kind of had to unravel some stuff to fit that model. But yeah, I think knowing this stuff up front and adjusting your subcontracts is going to save you some potential headache down the road.
Yeah, the subcontractors are pushing in New York State, have been for years, to outlaw retainage altogether.
Really?
We stood firmly in the way of that on building work. There's another matter on highway work, but that's a matter for next month. but it's certainly an issue and a concern to not have retainage at all and that ability to work through that as a management tool. I mentioned the Wage Theft Act in a big risk. But before I get there, one thing I want to point out is that as we've been talking about subcontractor payments, and I talked about the risk there, what subs can do. I want to make clear on something that you have a similar time frame as a GC to pay your sub from the time that you get paid by the owner, or give the subcontractor the reasons why not. And understand this: if in that whole chain the subcontractor feels they have not been paid timely, they've got some rather unique and difficult tools to make things painful for you. They can stop the work. They can stop their portion, or they just walk off the job. And so, it's something to keep your ear to the rail to find out whether that's something of a risk, because oftentimes they may walk off at the most inopportune time possible. And what is that going to do to the rest of the subcontractors, and how do you manage that with your owner? So they really need to think about. They also have another tool available to them, and it's binding arbitration with the American Arbitration Association. It's rarely been invoked, but it can be a problem. And knowledge of those pieces and the risk with a subcontractor is going to be, I think, important for you in your communication with your client on the whole payment issues. If they should fall down on this stuff, the risk to the job, the risk to schedule, all the way around could be very, very significant. And as I said, it's important to keep your ear to the rail. I mentioned at the beginning the significant risk in New York State that was imposed on GCs last year, and that's the Wage Theft Act. And it makes the GC liable for subcontractor underpayment to their employees, their workers, and it allows a direct action by those workers and their representation to the GC. I won't go into all the details of that law, but when we look at payment, what you see before you is some language that we recommend, and we're working on maybe some other pieces to this, and I'll explain why in a moment. But it's important for you to manage this process, manage the payment process. One of the things that happened in the passage of the Wage Theft Act is we were able to get inserted some additional tools within the state's prompt payment law on private work. And so the language you have before you kind of deals with that to make sure that you are getting some actual certified payroll records. And I know that may sound like more trouble than it's worth, and maybe you pick your spots, but without that, you don't have tools to, one, know where the problems are, and two, to perhaps enforce it later on. I've had some discussions with district attorneys' offices and about this issue, because they love going after wage theft issues directly with an employer. And I said, well, you're not going to be able to do that in construction because they can go directly to the GC and you'll be cut out. And I said, well, you'd be willing to go after the perpetrator of wage theft when you're going after that for the GC. I know what might not be as sexy as going after it for an actual worker and giving that check. And what they said was interesting, that yes, they would be willing to entertain that, particularly if there is a fraudulent documentation. So if the wage payroll records that are provided to you by the sub, and no, we talk about they've got to require their subs as well to do this. If there is a fraud in those records, then that gives a stronger impetus for the district attorneys to go after that subcontractor and get your money back. The other thing that I will note is, it's nice to have those payroll records, but what do you do with them? And the biggest risk area that you're going to have in this regard, in my view, is what I affectionately term lumpers. Those are the so-called independent contractors, the sheetrockers that are paid by, as independents that are really not independents. I won't go again all into the details of this, but as you're looking at those records and doing spot checks and checking them against your daily logs of the number of workers, and you say, all right, there are 30 workers on here. I'm only seeing records for 20 of them. That means I got 10 lumpers. And that's a risk for you. That's a huge risk for you. And something we'll discuss in more detail. We've had webinars on this issue as well. But as you go through the subcontractor payment issues, this is something to keep an eye on because it is a major risk for you on your projects. So with that, I want to open it up to questions. And obviously, as we say, always, call AGC first, and we'll help you out where possible. Also, obviously, there's a QR code to schedule a demo, if you wish, of the Document Crunch tools, which are very, very important in our view to helping you identify the issues and some of the recommendations, which, as I said before, will include recommendations on how to deal with subcontractor payment provisions on pay when paid versus pay if paid, to stretch that out as best as possible. Brendan, doesn't look like we've got a question coming up here. Let me see.
Yep.
Can you run through a hypothetical situation from the GC standpoint of wage theft? How would it start? Once we prove it was not our doing, can we back away, et cetera? Well, as I said, the big risk is going to be a use of improperly classified independent workers, independent contractors, and the law, not the Wage Theft Act, but other laws have a pretty clear definition that we actually negotiated legislatively about 11, 12 years ago as to what the 11 point test of that. But generally, you'll know them if you see them. If they're putting up sheetrock, they're probably illegal in that regard. So that's one of the big areas. The second big area is going to be underpayment of union benefit funds. And that's just something you need to keep an eye on in talking to your in talking to the unions, even if you're not signatory, to have a good chain of communication with them. The next one is going to be shorting on the hours, and that's something that that you're going to maybe see in the certified payrolls. Probably not. You may see some kickback situations, and that's a matter of just keeping your ear to the rail. What are you hearing out there in the field, and try to identify that. That one's hard. Your ability to back away, not so much. The law does not allow you to back away from this, but you need to again keep an eye out. Kind of manage that as best as you can, looking at certified payrolls, looking at your retainage, and abilities to hold back money if you've got an inkling. but a lot of this is going to hit you hard, and it's hard, and this is an almost impossible thing to manage. Next question. So this platform will be able to give your project managers a cheat sheet on subcontractor retainage from the start of the project, what percentage to hold based on what owner holds. Well, I'll let Josh talk about the platform, and then and what that's going to look at, and how that's going to bring in some of our comments as to what can and should be done. You're muted, Josh.
Yeah, I'll take that. Yeah, it's a great question. That's precisely what the platform would do. You would be able to run that prime contract through there, understand what the retainage was. And then, I believe that Joe has added some notes in the retainage section of the AGC New York's, product that would remind you exactly what Joe described today. Maybe not exactly, but would certainly tip your cap toward that exact issue that you raised. So that is how Document Crunch works.
Yeah, and where appropriate, as I said, when you get that report and you click on the piece on pay if paid versus pay when paid, we provided you with some specific language recommendations in that regard. And this is based on something that we did back shortly after the West Bear decision. We had a team to work up some language in this regard, in similar fashion relative to the wage theft. We have a guidance document on that. So it's gonna pull up those recommendations based on those items, and I want to take a moment, since I'm bringing those up in the recommended language. We have, besides our relationship with Document Crunch, we have a lot of lawyers on our committees that help us in this regard, and we can't thank them enough. But yeah, it's going to. So the platform is going to identify those areas, and so you're going to see if the payment provisions are in line with the state law. You're going to see if they're off the rails, and then you need to be starting to think about how you manage that. If you've got an owner that's saying, yeah, we're gonna pay in 120 days, whether you like it or not, we're gonna pay you in 120 days. All right, we better start thinking about how you're going to manage your subcontractors at that point in time, because you're in for a rough ride. Any other questions?
I don't see any at this point.
All right. Well, we're always available. You've got the contact info. Hopefully, you've hit that QR code. We've left it up there long enough for you. As I said, next month, I think it's the 16th of November, we'll get into prompt payment and retainage on public work, which gets into some different categories, but there will be some similarities on this, but we'll get into more detail on some of the state laws for public work on payment, some of the considerations there. So thank you all very much. Hopefully we'll see you again next month. And as I said, please reach out when and wherever necessary.
Thank you, everybody.
Thank you, everybody.
Josh and Josh, thanks.
Take care.